It's Cash Color Campus, a high level of conversation from Live Hip Hop Daily Studios, and this episode is sponsored by TrueLeave. If you are a Georgia medical card holder searching for good quality products, stop by TrueLeave. Flour, vapes, edibles, topicals, concentrates, tinctures, and more. Visit one of their 5 locations in Georgia and find out what they have for you today. Matter of fact, you can click the link in our caption or click the link in our bio right now and search the store that's closest to you. Without further ado, we're back in the studios today. It is hot as anything in Atlanta. 95 degrees is hotter than me. I'm from Boston, and I like seasons, but I don't like you know what I mean? Like my mom told me it was 89 degrees today, and I said that's for me. Like 89 is good for me, man. But
it's a good measure.
It's kind of cool in here, and I got a cool guest with me today, like my friend Jasmine Mize. Hey, Jasmine.
Hey, Mecca, how are you? What's up? What?
No, the way you did. Hey, I'm cool, man. Thank you for coming on. Like, it's been cool ever since I met you. We've been having some good conversations, some good synergy, and I felt that you would be the perfect person to be on for today, primarily because I've been looking up, making sure I'm trying to trademark Cash Color Cannabis, and I've actually been hem-hawing around about it.
Yeah.
And I had a moment this past weekend where I was watching a podcast, and somebody was talking about how a partner there has trademarked their brand. And I actually got super nervous. Like, I went on the trademark, and I knew they couldn't. Like, I've had plenty of conversations with attorneys. I knew what could and couldn't happen, but I'm still like, let me check. Went and checked my name, and I actually saw something. Somebody actually has a trademark for Cash Color, but it's for a smoking products line. That was the closest, and I was like, you know what, by the end of this month, I got to wrap this up. And then I thought about you, and I said, let's go up here and talk about intellectual property and such.
All right, let's do it. Because what you just described, a lot of people experience it on a regular basis. Wake up one day, realize they feel very unprotected. They feel very vulnerable. I hear a story, somebody trademarked their idea, a former business partner, somebody maybe that just has a tangential relationship to them, just stepped in, just really, really admired might be the best way of putting it, but somebody's idea, somebody's trademark, someone's logo, and then what happens is just chaos, and it unravels a lot of hard work that one might have already done.
Yeah, and it's also a good conversation to have because people often don't think about the business side of things until it becomes a moment where you need to know about the business side. So before we get into all that, please introduce yourself. Tell us fully what you do.
All right. Well, my name is Jasmine Mize. I'm an attorney. I am a Washingtonian. I'm originally from D.C., but I'm living down here in Atlanta. And I started out my legal career actually as a public defender. So for 8 years, I did public defender work on the state and then the federal level, and some opportunity came my way to join a law school faculty. I went and taught at the UDC Law School in their clinical faculty, and I worked with this really dynamic colleague of mine. We both came from the government, and we were trying to switch gears, and I ran a civil legal clinic with law students in DC, and one thing I really wanted to pivot the work towards was doing this reentry work and getting students to help us do sealing act cases. So basically finding clients that had records of arrest and conviction and were eligible for sealing their records in DC Superior Court. So I did that for a couple years, and I really got entrenched in the idea of what is a civil rights lawyer. What does it mean to practice on the civil side, taking cases, taking steps, advising folks on kind of how to undo some of the experiences they've had having contacts in the criminal justice system. So I came down to Atlanta. I worked for the Southern Poverty Law Center. I did class action litigation, suing the government, suing departments of correction, doing all that fun stuff. But now I kind of have stepped away from doing the kind of classic litigation stuff, bringing big cases, suing the government. And now I work with folks and just kind of creating and supporting and educating on small business support, entrepreneurialism, and a lot of folks in the cannabis space, which has kind of always been a through line. I defended a lot of drug cases when I was a public defender. I really got burnt out because of how many drug cases I had to handle, just took all those experiences and dug into a lot of cannabis work since I left criminal defense work. So that's me. I say I'm a civil rights attorney, but I dibble and dabble and do a lot of work with cannabis businesses.
Girl, public defender, I know that burnt you out. Like that's a job that you don't get paid a lot to do.
Yeah, I always say you're the best lawyer that money can't buy. And I stole that line from a mentor because I felt like it was the most clever way to describe the work. because every PD that I've ever worked with is just a kick-ass lawyer, but we get burnt out, and unfortunately, you know, there's an expiration date, and a lot of folks like myself, we just kind of pivot away and try to find another space and place to practice and do the good work.
Yeah, you know, I'm thinking about Law and Order because I'm a Law and Order fan, and I'm like, every public defender on Law and Order, man, goes through it.
Oh yeah, no, but I've had some really wonderful experiences, and actually when I went into teaching, they say, you know, you're supposed to publish or perish, and you got to write. You got to be this academic. You got to be super smart. You got to write something. You got to sound smart. You got to go to conferences. And they're like, you got to write about something you know. And this is in 2015, and I had just reconnected with a client who was basically telling me this story about how he had come home from prison. He was on supervision in D.C. He got a medical card in D.C., and he was, you know, a medical cannabis user. He got stopped on a parkway in Northern Virginia, pulled over by park police, got into federal court with a misdemeanor, ended up getting a violation, right? Basically because they tested him and he tested positive for cannabis, but he's like, I have a card, right? So we go into court like, this can't be a violation. He has a card. That's the saving grace. The judge is, you know, kind of in this fancy courtroom with the wood walls and everything. He just looks at me, and I'm making all the creative arguments, and he's like, I don't know what to do, Miss Mize. You tell me. It's like, what? You know?
Not guilty.
That's what I said back, like, dismissed, you know, dismissed. I think this is, you know, he's a valid medical user in the District of Columbia where he lives. He works in Northern Virginia, so he's got to cross borders, but he has a valid card, and that should basically allow him to use his medicine. So that's kind of what got me started. So I wrote about that experience. I wrote about my client. I wrote about how he got all this stuff from his PO to kind of make the case, and we make this fabulous argument in court, and the judge just looks at me like, I'm so disinterested. You just tell me what to do. Like, I don't care about this issue, right? But then I'm like, but I do, you know? So it's like it tapped into me, and so I wrote an article about it. I kind of, you know, I went to, you know, all the academic conferences and was just talking about cannabis criminal justice issues, and this is 2015 where all the fancy professors are like, that's interesting, but let's talk about something. Like, they weren't really too taken with it. Yeah. But flash forward now, almost 10 years, I'm sure it'd be a different game if I walked in with that topic for discussion.
It's interesting how quick things have changed, because from 2015 to right now, at one point this was, I mean, it still is looked at by some people, but it was looked almost like a gimmick, you know, like, we're just talking about weed. But now, you know, there's plenty of attorneys, there's plenty of people who are coming from the other genres who are seeing the opportunities here. Oh yeah, and I've gone to cannabis law conferences, interfaced with run the gamut, A to Z, with cannabis lawyers that do a lot of good work, you know, pushing the envelope forward, getting people into business, getting their licenses, you know, defending them when the government operators, you know, the regulators come by and say, you know, they're not up to code or they're not in compliance, you know, doing a lot of interesting legal work that, you know, I like to keep tabs on and see what the arguments are being made. You know, just recently I had a client who actually, we worked on sealing his record in D.C. Superior Court. He lives down here in Atlanta. He had an old case from like 1991, you know, possession and some other misdemeanor offenses. We got his record cleared, but he has this one lingering felony he can't get wiped off his record, which is because a lot of the sealing laws just kind of exclude that. Like, you can get everything else, but when you have a felony, you can't get that off your record. We got to rewrite those laws. And so he was talking to me about, he's like, all I care about is getting my gun, like my gun rights. I want my Second Amendment rights. And he opened my mind up to this whole area of law, particularly here down in the South, where, you know, it's a little bit different culturally. I come from D.C., where it's just recently folks is talking about Second Amendment rights, but generally speaking, it was a high level of gun control my whole life, you know, growing up, very progressive attitude towards it. But down here, folks is like, okay, I don't want, if I get a medical card, I don't want that to prevent me from being a gun holder, right? Because a lot of medical rules that are being written are basically saying you can't have them both, right? If you have a medical card, you can't have a gun. Which is weird. Yeah, it's like, well, how is it that we've managed to make those exclusionary to each other? So I connected with a lot of interesting lawyers that do this practice, and I actually think it's a super interesting area that deserves a fight, but that may be for another episode. Because I'm thinking now, you got my mind thinking. So if I had a gun license, would that stop me from drinking? Like, would that stop? Would they say, well, no, now we don't want you walking into a bar? It's just discrimination. That's what it is. It's treating certain people differently, and the certain people we're talking about are people with medical cards. You know, and it's unfair because, as you know, from a lot of, you know, 30 plus states that have medical programs,
and many that have gravitated over building out an adult use program starts from medical, right? Like a lot of medical programs get up off the ground and start, being available to the community, like here in Georgia, before people are even saying adult use, right?
Before we get to rec.
And so, unfortunately, it's like the first taste we get as a consumer or a medical cannabis user, all this discriminatory stuff comes on top of it. Like, you can't hold a gun. You have a medical record, you're on a certain database. Let's say you're in a custody battle with, in court. These are facts that start coming up, like as if it's relevant, to whatever legal issue you might have at hand. So it's just discrimination. No more complex than that.
That's wild. So I got approved for my medical card today in Georgia, and they had mentioned that you go on a database. And I didn't even think about it until I thought about it, but I didn't think about it until right now about how, is that a chance? Like, if you were ever in court, they could pull your name up and be like, well, he's also on this.
Yep.
And I'd be so mad because all you can get is THC, like low oil. Like, I'd be so pissed off.
Right, and it's totally apples and oranges, right? One has nothing to do with the other. And I came up with this issue. I was a victim of a violent crime when I was living in DC most recently, and I have a medical card there, and I thought very heavily about getting a gun license. I was trying to do it legally, and I came right down to the line of scrimmage. Like, do I get this or do I revoke my medical card? Yeah. And I just said, I've lived 40 plus years without a weapon in my home. I guess I'll forego.
Oh, you forego? Wow. I would have forego the weed card. Like, I could always get weed.
See, here, these are the debates that we shouldn't even have to have with ourselves, right? Yeah, because it doesn't make any sense. Just recently, the Supreme Court took up the issue of, like, can you have a gun while you have a protective order against you? So if you have an order of protection in domestic violence case, some guy from Texas took it all the way up to the Supremes, and it's on their docket right now to decide whether that's discriminatory. Like, if you agree to a stay-away order, right? 2 years, no contact. You can't reach out to me, all this stuff. But at the same time, if you have an order of protection placed upon you, you have to give up your gun license for that 2-year period under state law. Yeah. This guy rolled it all the way up to the Supremes, and they're basically saying, that's a good issue.
It's a good issue, but it's kind of your fault.
Right, but I say that to say that it's like being a medical cannabis card holder shouldn't be as prohibitive as having an order of protection against you because there was some domestic violence situation. So it's like, wow, if they're considering that issue, then this should be super simple to decide, which is like, we shouldn't have to choose. Yeah. That's just discrimination.
Yeah, it sounds like something they were trying to put in place in order to see if people would vote against, legalization, or people would start siding against legalization. Because like you mentioned, I have a choice to do this or do that. Me, I just go get weed off the ground, off the underground. I'm keeping my burner.
Right, yeah. I guess I just didn't want to buy into the discriminatory aspect of it, so I was like, let me hold my ground and.
No, you did the right thing. Don't let me dissuade you. You did the right thing. You stood up for the right cause. I'm just saying me in particular. Yeah,
no, hey, and I don't know. Depending on the hour of the day, I don't know which is the more righteous cause, right? Yeah. Like, I'm like, hey, they're both rights I should have. They're enshrined upon me with respect to the laws and the Constitution, so I feel like I shouldn't have to choose, and no one should. So. I think it's an issue.
You know what? Before we get into trademarking, you are from the D.C. area, so you should be familiar with Maryland. Last week, I had a conversation with Brandon Wyatt. Shout out to my man Brandon Wyatt, Kevin Ford Jr. and Roz McCarthy, and also my man Colin Frazier about Westmore, Governor Westmore pardoning 175,000 cannabis convictions. And the conversation we had primarily on the show was whether or not that was enough, meaning cleaning people's records. Like it's one thing to pardon them, but what's the next step here? Like, is it going to be a push for that? Like, how did you feel when you first heard that news?
So, hey, I always try to look at the positive before I come with my critiques, because they're going to come.
I know you a lawyer. That's what Brandon did, too.
So I already know, because Brandon is an excellent lawyer. So here's what I like. I say a point towards the positive, because what Westmore has done is he has demonstrated that on the state level, it's actually more impactful that an executive takes the step of an automatic pardon, particularly when it comes to prior drug crimes and cannabis. Given the shift change in the laws on the state level in Maryland, they have adult use and medical program there for a while now. And so what it's basically done is shown that, basically, take a step back for a second. Biden did this commutation and pardon business about 2 or 3 years ago, right? Which, again, point towards the positive. We got, 6,000 possession crimes that he pardoned with respect to federal offenders that had gone through the federal court system. But the reality is, greater than 80-something% of drug crimes are charged prosecuted and sentences handed down on the state level. So that's where the action is. That's where the prisoners are being held for drug crimes, not just possession, distribution, distribution with a weapon, all kinds of things that are wrapped around the axle of drug crimes are happening in a more fulsome way on the state level, right? And so what Wes Moore did was basically say, I'm the executive of the state of Maryland. I'm standing up for the fact that the disproportionate impact of the war on drugs that has hit certain communities and has rendered folks in a discriminatory posture, like they're being discriminated against because of their prior record. I, as the executive, am going to take this step that basically simplifies the process. Automatic pardon. You don't have to hire a lawyer or fill out a form and file it with the court and wait for an answer, and maybe the government might, fight or object, and then you got to have a whole battle about whether you should get your record cleared. So Wes Moore is standing up for the principle that all that action on the state level is way more impactful than it is on the federal level, just by numbers alone. And so that's a point towards the positive. Now, what I will say is, like, perhaps what he's planning and sort of teeing up is this idea that that's where we start, right? We start with simple possession crimes, which, really, when you look at the statistics, simple possession crimes impact mostly users, because that's who's getting locked up for possession crimes.
That was another conversation we had,
The real action is, and we've got to open our minds and our eyes up about the carceral state, is most people who are serving significant sentences, cannabis and drug-related crimes, are serving for distribution offenses with firearm weaponry that kind of tax on mandatory minimums. So we have to open up our perspective on whether or not just pardoning possession is really doing the work we need to free people from incarceration, currently serving long sentences. You get a drug crime, a distribution crime, and the government tax on a gun charge, that's 5 years mandatory under most state and federal, court systems. So it's like, okay, if we're talking about freeing prisoners and reducing our carceral state, we got to go further. But Wes Moore knows that, and he's trying to take some steps towards that goal, and he's a smart, incisive mover when it comes to, what does it look like when I take this leap? It's impressive. It's good. Other state executives should follow. The growth and building on that should follow also, right? Like, the next step should be thinking about expanding what we allow for pardoning and get folks that have drug crimes that kind of implicate more serious offenses, but that actually makes the impact and releases people from custody and reduces our carceral portrait, basically.
Okay, so.
But Wes Moore did a great thing. Wes Moore did a good thing, and it's an example to follow. So that's awesome.
It definitely is. There's always a next step. And that's one thing we will all be able to agree upon after even our conversation last week. There's always got to be a next step. Like, this is big, but what's the next move?
Right,
and it was a great way to open the door. I thought that.
Absolutely.
So when I first met you, it was you were doing a class at Bookstore Gallery. Shout out to my man Kyle. You was doing a class at Bookstore Gallery, and you were discussing what we're discussing today, which is protecting your intellectual property, how to trademark your brand, how to protect your brand. Speak to us about the importance of protecting your brand in cannabis and how people miss out on that boat.
Sure. So I guess I'll start with, recognizing and giving props and power to what I would say is the unregulated cannabis market right now, which is, we know a lot of businesses, entrepreneurs that either operate in states where the licenses don't exist, or operate in states where they missed out on an opportunity to get a license, to be a cultivator, to be a retailer, to be in the strictures of the established cannabis business. And so they kind of operate on the outside, or kind of on the outside contours of what we'll say is the regulated market. And these are folks with a lot of ingenuity, a lot of skill and talent, and are potentially, and maybe most likely, kind of looking for future opportunities, steps to take to potentially over time regulate or become a part of a regulated market, right? And so I work with a lot of folks who are described as such, right? Which is, they have great ideas, are kind of in the middle of building a brand, and at some point hope to, as an inevitability, become part of a regulated market. But in the in between time, I like to work with those types of clients and talk about things that they can do in the moment and utilize the current laws in other subject matter in order to best prepare oneself to enter a regulated market down the road, right? When licensing opportunities become more plentiful or open up in general. And so that brings me to this topic of intellectual property and trademarking and patents and trade secrets, because I work with a lot of folks that kind of in a hopeful space, right? And I encourage them to kind of think 1 year down the road, 2 years, 3 years, 4 years, and so on. And one thing that they can do now is assess their brand and figure out a way, like we were just kind of starting the conversation, where someone can't come along, a competitor, a larger operator, and take their ideas, right? So because intellectual property is basically like, it's about protecting your creative work, right? Your ideas of the mind. There are different types of intellectual property. There are patents, there are copyrights, there are trademarks, there are trade secrets, and there are sort of like different types of what I just described. Those are the kind of big four. And in cannabis, I think the most applicable are, generally speaking, trademarks, trade secrets, and patent protections. And the reason why I kind of have these conversations with clients and talk to folks about it is because it's available for one to do and take the steps like now, right? Yes. While we're in this space of, we get the rescheduling mandate from the DEA, and that kind of, we're thinking like that kind of loosens up the reins on the federal level, and we're hopeful about where things will go. So we're thinking about what can we do now and utilize the time now to build our brand and protect it, so that eventually once these entrepreneurs in a space to enter a regulated market, they're not vulnerable, they're not susceptible to someone who sees the value of their business and wants to kind of gobble it up and use it and market it and utilize it and put it in a stream of commerce and give you no value back, right? So it, to me, is kind of part and parcel of working with folks that kind of just see themselves entering a regulated market in the future, or maybe potentially just work as an ancillary brand and never intend to be flower touching or in the or a cultivator or a retailer, but have an ancillary business that is a genius idea that would be any MSO's dream to kind of gobble up and use in order to build and keep growing as a large operator in the space. I swear I'm not going to hit that chord no.
I agree. I see a lot of underground brands. They come up with really cool names. You know what I mean? And I always think about that. Have they ever tried to trademark their name? Because as you mentioned, this is a name that's really catchy. It's a real name that could really be applied to a lot of other things. Don't let this get gobbled up by somebody else simply because you didn't pay attention to what you should be handling, which is your business.
Right.
Even myself. You know what I mean? Just always make sure you're doing those type of things.
Right. And so I think of when I kind of start out this like kind of instructional session, the one I did at the bookstore, and ones I've done for lawyers even that don't really understand the interplay between cannabis and intellectual property, it started out by things that people recognize. I always start out by talking about cookies, the cookies brand, because for no matter who, it's a very democratically aware brand. Like everybody knows about cookies. Yeah. And what I say is like you recognize the font, the coloring, the style, it's on a slant across the brand. And the thing is, the cookies brand isn't limited to flour. In fact, that's the smallest of their brand portfolio. Cookies has apparel, it has accoutrements, smoking, like papers and other, accessories to a smoker's pantry, I guess you could say.
Burner easily has several trademarks.
Right. And what he's trademarked is the actual word cookies in the style in which we are so used to seeing it, which is in that font with the like kind of slanted diagonal on the kind of like arcing towards the right, and it's very recognizable, and he's got trademarks for that logo, and he's tacked it on literally everything he sells, which includes flour, right? And so where it started though was with apparel and accessories, and so I say that to say that if at first where you're at now in terms of like commerce, you're not selling or doing exactly what you envision yourself to do at the end of kind of like the end of your trajectory, trademarking your your logo is a very important step to protecting what your vision is like going forward, right?
And I was always confused. I felt like you should copyright your logo, trademark your name. But I found that out even the last couple of days, even looking up stuff, that yeah, it's probably imperative that you also trademark your logo as well, because
Right.
you know, you don't want somebody to come and use that, put it on like Bart Simpson. I remember back in the day with the black Bart shirts. Like I'm pretty sure, you know what I mean? Like the Simpsons was going hard on that. Like they were trying to
Right.
shut down anybody who did that because that's their property.
Right, and it was so popular, right? So
Yeah.
they're like, we can't distribute this out without us getting a cut of it, and that's
Correct.
kind of the point. So, you know, there's a lot of intersections between like what intellectual property applies to what. So. I usually start with talking about patents because it's kind of like pretty specific. A patent is basically a formula, right? So it's an invention that has a formula, and this applies in the cannabis space a lot to agricultural and growers and cultivators, right? So if you are super talented at a particular method upon which you grow or a strain, you know, folks are making new strains up as we speak.
As
you
you're
know,
talking, I'm thinking about Runts. Is Runts
Right.
trademarks? Like as
Right.
much as you hear Runts. Wow.
Right, and well, the Runts logo and I believe there may be, well, the logo is trademarked, right? But then for a futuristic goal of tagging it to the flower that's grown with the strain, right? So one thing about intellectual property protections is it's governed by the federal government for the most part. Now, states have their own intellectual property rights and rules, but it only really governs the state. So if you get trademarking in Georgia, someone could just go to South Carolina or Florida and literally imitate it and wouldn't be breaking any laws. It's the federal protection that you want because it basically protects anyone anywhere in all 50 states from selling your goods or using your logo. And so you want that protection. And the federal rules about any patent or trademark or copyright is basically say it has to apply to something that is being lawfully used in the stream of commerce. So the Farm Bill changed the game in that it basically opened up the door just a crack to hemp product and hemp flower and hemp agricultural products, and also THC flower within a certain margin, right? So there are about 100,000, I think, patents pending with the U.S. Patent and Trademark Office for flower and genetics associated with.
That's smart though. Yeah, especially genetics. That's
Right.
super smart.
Right, yeah. So the genetics associated with flower that comes within those margins that are allowable under the Farm Bill, right? Because you can get federal protection because it's been taken out of the federal crime code, right?
Yeah.
Anything under the 0.3%. So patents really kind of apply to formulaic stuff. You know, it's something, it's an invention, genetics, something has a formula. Trademarks apply to a visual representation of your brand. So a logo, a color. There's something called trade dress. So you walk in an Apple store, you know you're in an Apple store before you even see the apple with the little semicircle, right? It's because every store looks the same, right? And MedMen kind of use that tactic, right, on the West Coast, where basically all their stores look the same, and that's what's called trade dress. Coca-Cola has its own trade dress with its bottle and its logo.
Yes.
The Tiffany blue, right? You can trademark a color. Christian Louboutin, red bottoms. That's a Pantone patent for that brand of shoe, right? With the color of red on the bottom of those shoes. So we're talking logos, colors, trade dress. These are visual representations of the brand, and that's a lot of where the action can be. That's a lot where the action is in cannabis because, like you said, you're talking about all these creative products and brands with visuals that can be trademarked, right? And the trademarking kind of falls into categories. It depends on what your product is. Is it apparel? Is it ceramic ware? Is it dishware? Is it pens? Is it lamps? It could be products, right? And there's a bunch of categories. And then you also have what's called service marks, right? So you can apply a trademark to a service mark, which talks about services. So if you provide information, right? So if you have a website and you provide information about cannabis, you can take your logo and apply it to the information that you provide on your website.
You're giving me a lot of good tips here right now.
Okay.
I feel like I'm getting free legal advice.
Well, that's the goal here.
One thing I thought about too, as far as seeing things on the underground level, was how many times I've seen brands co-op other brands that are in mainstream markets. Like you often see Rice Krispies, or you might see a Kellogg's thing like that. And I remember when they was trying to crack down on that, you started seeing major brands actually start making a stand to say, no, you can't use our product.
Right.
Yeah, that's important as well. You know, making sure that you're not using something that's already used and trying to recreate it into what you call your brand.
Right. So basically, the trademarking, or the process by which you would get a trademark is, and you can do this. I mean, people hire lawyers to do it, but I think it's pretty accessible as a procedure. It just takes a long time. If you go on the USPTO website right now, there's a ticker that says we are looking at applications from August of 2023.
I was there Saturday. They show
So
up.
it shows you how fast or not fast they move,
Yeah.
right? So that's one thing. That's why I say now is the time. The best time is now to work on trademarking your brand. But the process is basically really simple, and I'm sure you kind of gone through some of these paces, right? Like, let's say you have your trademark, right, and your logo with a combination of words and symbols, and you look up you basically do a search on the site and see if someone else has your trademark, right? And if something, usually you find things that are kind of close to what you have.
Like I did with Cash Color.
Right,
Like,
with Cash Color.
Yeah.
Then you kind of know that, okay, it's worth the try to apply. But once it gets to a hearing examiner, you may have a fight. The person who holds the trademark for what you think is kind of somewhat similar, you may have a fight there, a legal fight. So you basically, it's like any legal fight. I say yes, you say no, and then we let a neutral arbitrator decide, which is usually the USPTO office, right? And you make arguments like, well, my product is different. We're in different categories. Your zone of expansion, that's a term of art, is different from mine. I had a business client that is a cannabis education company in New York. The name of it is Cannaware. And they were trying to get trademarking and did a search and found that there was a trademark for a ceramics company called Cannaware that had like the cannabis leaf and sort of these pottery ceramic goods, right? Cannaware in New York, which is like a portmanteau of cannabis and awareness, right, is not selling ceramics. So I encourage them to proceed because it's like, I think you'll win the fight. I think you can both have a trademark in different categories and service marks for the instance of the New York-based business. And I think that that's a go. I think that's a green light. So don't be like dissuaded if something is super similar, because I think it's worth the fight if you can say my zone of expansion is different from your zone of expansion, and plus I've been using it longer and you just came along, and here are all my evidence to say you copied me, all that kind of stuff.
Wait until I walk in the court. My zone of expansion, baby. Since 2016, it's not the same. We're not even the same category. Y'all are smoking products. I'm a media company. Like, who cares?
Yeah. So these distinctions are with a difference, right? And so I think it's like, don't be dissuaded if you see it. Keep pushing. Maybe you think about if you kind of maybe lose the skirmish of that, you could change you could think about changing certain names. Some people aren't totally wedded to their, combination of logo plus words. You can think about changing it, but don't retreat if you don't have to.
Yeah,
it's kind of the rule of thumb. I think I've been like, somebody was telling me about this whole thing about Eminem was suing some Real Housewives for having a podcast called Reasonably Shady, and he was saying they were illegally.
Like Marshall Mathers, Eminem. I thought you meant Eminem the brand.
Right. Like Marshall Mathers, who we haven't heard from in a while, talking about, I use the term shady as like Slim Shady.
Yeah.
Everybody wasted a lot of money on lawyers for him to kind of lose that fight.
Yeah, because it's a different kind of shady.
Right. Yeah. Like rapping, podcasts. Yeah. Totally different. So I say don't retreat unless you have to, but the USPTO makes a search engine possible for you to see what else is out there, so you kind of know, and then you kind of work within what you might have to prove, how long you've been using it, how different your categories are, and then let the games begin.
You're right. I suggest that, man. People need to go ahead and search their names, just to make sure what is close, what is not close, because I was one of the people initially, and I feel so bad saying this because I do have access to so many amazing legal minds that I felt like it was going to be so complicated to try to do on your own. It's not necessarily super complicated, like you mentioned. It just takes a while.
It just takes us. It's little persnickety. It's like you gotta kind of do it exactly as they say, and then once you get a hearing examiner to look at your case, then you're like dealing with a live person, and it becomes a lot easier, and you can make your arguments, and you know, yes.
Is it similar to if I go like to GoDaddy and search a website name? Do you have a chance to be like, oh, that means it wouldn't be trademarked because the .com is here?
Well, that's an interesting question. It could be, and it could not be. You know, I don't know if that's necessarily the marker, because a lot of people get these domain names and don't have any intention of protecting anything associated with the business. So I wouldn't say that's like something to get dissuaded by either, right? Just because somebody has the domain, I wouldn't worry about it. It doesn't mean, it doesn't necessarily, the real search is on the USPTO site, you know, and, you know, folks that have a big vision, right? So I always use this example when especially with lawyers, when I talk about patent and trademark with lawyers about cannabis. I talk about Willie Nelson, because in the IP world, they look at him as like having done it absolutely by the book perfectly. So Willie Nelson's whole identity is like associated with smoking weed, right? Like since he's been an artist in the world. And he some years ago decided he was going to build Willie's Reserve as a brand. And he started just like cookies, right? Which is like apparel, the accessories, the rolling papers, and basically trademarked the words Willie's Reserve with the logo and the kind of like old Western kind of motif that he has associated with the logo, trademarked it with the federal protections, right? Put it on every product he sells. Then he went into Colorado and applied for patents and trademarking for flower touching products, because it's legal in Colorado, right? All of his products that are for sale in Colorado, and got Colorado state protection for his flower products and put the same logo on those. Basically, he's first in line when the U.S. Patent and Trademark Office opens the floodgates for full THC products to receive patent and trademark protection. So whatever genetics he has going on with Willie's Reserve, he's basically got, I have goodwill built up so much so that the only obvious recipient for all of this protection is me and my business. So patent and trademark lawyers talk about Willie's Reserve as having done it all by the book, which is basically just a message to say, like, if you have an end game and you know what you want to do, any and everybody can do it. Follow the book, right? Get your trademark logo, you know, your logo and image and language that is your brand. Get it trademarked, put it on your products. It obviously can't go on plant touching products right now based on federal prohibition, but in the future that will change. And then you have the goodwill, and that's another term of art. If you've built up the goodwill, you're the natural recipient for the protection.
Yeah, I feel like, well, again, people I feel like need to get out the mind frame of, like I remember using poor man's copyright a lot. Like when I would write a lot of things, like scripts and things like that, I would just mail it to myself and never open it. I have 3 envelopes right now of scripts that I have never opened ever. One of them I feel like is The Wire. And I've wanted to,
hey, let's open that.
I wanted to go to it so bad because I'm like, I know the concept of this, but I know nobody else knows about this. But I feel like we need to get out of that mind frame as well. Like just take a step. Like it's not the hardest thing to do. And if it is hard, there are plenty of people you can actually tap, like yourself, who can actually explain to you the process. But it's very important for you to protect your business. I'm still going through that myself as well. I do know that since we've been doing this since 2016, I know I have goodwill with doing that. No one else has even tried to do cash color cannabis. If they tried to, they contact me if it would happen.
Right.
But also still, you need to have this. You know, you never know.
And
plus, I don't want to be, not to cut you off.
No.
I remember the situation with Nick Cannon and Wildin' Out. Like, I remember when he was leaving Wildin' Out and people was always arguing, well, he owned the name, and come to find out, no, that wasn't the case.
Right.
I don't ever want to be in a situation where I do a bigger collaboration or a bigger partnership with a bigger brand, and then come to find out when I leave,
they took everything.
Yeah, no, you didn't really own that. So
right, and that actually brings to bear like something that's also an important sub-part of this, which is you're a media company, right? And your brand is media. So you produce content, and it's not always just like concise word bites or just Cash Color Cannabis with your logo, right?
Yep.
You write, you speak, you produce, right? And you create content on multiple platforms that isn't just, like I said, relegated to a concise sentence or a few words. And you and what you produce may be more formally suited or better suited for copyright protection because of the volume of what you write.
And that's what my friend Shay Lawson, she's an attorney down here. That's what Shay recommended to me years ago, that you might want to copyright versus trademark cash
Right.
color cannabis. I kind of want to do both. I feel
Right.
like it's
I
worth-
think you should do both.
Yeah, it's
I
kinda-
think you should do both because trademarking is a very succinct concept. It's just the image and the wording, right? A logo. And then you receive it and you place it on things. It's almost like literally like a metaphorical sticker, right? And you place it on there and it's something of a protection. But the volume of what you write, eventually I think you do want to copyright it, because copyright refers to, and we talked about this a little bit, like kind of more prolific writing, right? Lyrics, novels, books, and you can think about the length of all of that and it runs the gamut, right? But it's more than a sentence. And so I think just based on the volume of what you produce and working with other companies in the cannabis space, think about copywriting, your pieces of art, like your work, your writing, your magazine, in particularly your print media. I would definitely advise that. And you would do both, right? And the cash color cannabis and the logo and what you're wearing, and that is a more simplified process. And I say that's probably the shortest route to go to kind of protect much of your brand, like the imagery of your brand, and then start tacking that on, like literally just sticking it on there like a sticker, and build out the framework for protecting everything else that you do. Because then these companies, these larger companies that respect you for the content you put out, that just gives you deeper protection when you start producing more and more. And then that kind of brings me to this idea of a lot of what exists in the content world. It may be appropriate for a copyright protection because that's like sort of this specific type of work of art. But we also have what are called trade secrets, right? And that, talking about, I mentioned about formulas and patents. A lot of businesses have formulas that help their business run that can be protected also by certain IP, which is really what's called a trade secret. So companies that have a customer base, right? Emails and subscribers. With millions of people that tap into Leafly or some other companies where they help you find a dispensary in a particular city or a space. The subscriber list, the methods by which you communicate with your customers, customer lists, things of that nature can be trademarked, or more specifically, it's called trade secrets. That can be trademarked. The technology that you use, the applications that you use to create access to folks to do delivery services in certain jurisdictions where they have delivery services. All of that is very sophisticated stuff that folks don't necessarily know how to do. And a larger company may come along and be like, I want that subscriber list of 1 million people that hop on this app to get deliveries in Philly, and that can be stolen essentially. If it's not protected by use of a trade secret. And I know a lot of people in sort of like the IT space should think about protecting the things that they help other companies build.
You have to, because even if you've ever watched The Social Network, learning about the Winklevoss twins versus Mark Zuckerberg.
It's precisely the same battle right there. That's exactly what it is.
Because watching that battle was for real, because they had an argument to me, but the way, man, look, that was...
Right, and it's like, it's a marriage of like ideas and execution, right? And the folks that come to the table with the execution skills, they got something to protect too.
Yeah.
The idea, like, okay, the concept, that's more akin to like a trademark, but the execution of it and the like subscriber, that's like a trade secret, and they're both different types of protections. And if like you don't have an agreement going in with a partnership, everything's for the taking once it's like you see the value.
Yeah, you never really know who's your friend until you get into business and certain things like this happen.
Yep, exactly. And there's a lot of vulturistic attitudes out here in the cannabis space. And, I think that's kind of extracting back a little bit. I work with a lot of small businesses and folks, like I said, and that are sort of enjoying the unregulated space because people appreciate it for its diversity, its accessibility, its relatability. But at the end of the day, they know they want to migrate over to a regulated space once it's a possibility for them. And the way they protect themselves from a larger MSO or another corporate entity coming in and taking what they've built up because they have ear to the ground is to use intellectual property protections.
I mean, now I have a whole nother question before we even fade out, because my new question is this. So if you're on the underground and you do have a cannabis brand, whatever you want to call it, you have one of those. If you try to protect that right now, or if you don't protect that, oh shit, I forgot what I was trying to say. Because I really feel like a lot of brands right now could really have their property stolen by bigger companies, because you don't have anything protected. But if you do protect it, are you still protecting something that's illegal? Like, you know what I mean? Like, would you put yourself in a bad position? That's what I'm thinking. Would somebody be able to, like, say, like, it's on an actual database? If somebody now types in the name Cash Color Cannabis and they know me as a weed vendor, does that now put me in a bad situation as far as me legally being able to get arrested because this is not a legal state?
So here's what I would say is that it's kind of like you kind of like sort it out in the sense of the trademarking, right? Is just the logo and it's the image and the words,
Correct.
right? And it can apply to anything that is in lawful use in the stream of commerce, right? So you wouldn't be able to, and you wouldn't want to try to take a trademark and put it on an illegal product, right?
Gotcha.
The idea here is you put it on a legal product, right? And then you build up the goodwill a la Willie's Reserve, right? And you build up the goodwill by using it, by applying it to legal product, right? Which can be physical items, apparel, it can be concepts, it can be media, it could be website content, things of that nature. And so you do that now in order to create the goodwill so that you are better protected later when the argument comes along about who has a right to it. And once the lawful use comes into play, right? Like, I think rescheduling is opening the window to that, right? We're kind of navigating into this pharmaceutical world where, like, you know, it's still not decriminalized, which is what we want, right? But rescheduling opens up the idea. Medical research is just a hop, skip, and a jump away from lawful use, in my opinion, right? And so I think any trademark attorney right now will kind of advise you to say, hey, this is the playbook. You take the incremental steps and you warm up towards what you would do eventually, which is take that trademark, which you receive, and then slap it on to what will eventually be a lawful product. Yeah. And that's the way you kind of gate them from taking away your ID in the first place.
So long story short, be more like Willie Nelson. Apparently.
He's a guy for us all.
Yeah.
I mean, you know, I'm not like a hyper Willie Nelson fan, but I will say this. I've gone to so many of these, like, continuing legal education, like, classes with lawyers that really know the trademark game way better than I do. I mean, they just do it. They breathe it every day. And, like, I've just never interacted with an IP lawyer that hasn't said, like, Willie Reserve, that's the way you do it. Like, that's the playbook. They literally say that. And I'm like, there's a reason why they say it. It's kind of like a legend at this point. Yeah. And it's like, I see what they're saying. It's a simple story, right? Which is you start here, you get your state level stuff lined up, and you just build up this goodwill. So then you're ready to rock with all your products when the time comes. And that's kind of the advice I feel like is accessible to anybody, which is like, do the steps now while you can, in the limited fashion that you can, and then you're ready to go and you're protected at the same time. Because I think, like, at the end of the day, I think that's what everybody's kind of major fear and issue is with, like, MSOs taking over the cannabis industry. And I don't necessarily say this in any pejorative way. I don't really have necessarily a aversion to, I mean, it's capitalism, but it's like what the MSOs don't have is a connection to the community, right? And then, so that's your value, right? But how do you protect yourself from eventually being subsumed by something that is naturally larger than you, that has more capital than you, that has more financial stability than you do? You protect it by saying, this is my creative work and it's mine and only I can use it. And if I want to sell it to you, cool, but you can't take it from me.
Awesome. Jasmine, you've been amazing tonight.
Well, thank you. That was like, it's my first time doing a podcast.
What? So. That was very knowledgeable. Now, yeah, applause, man. Jazz, before we go out of here, please let people know how they can contact you, how if they needed an actual trademark attorney, how they can get in contact with you. Sure.
So, you know, I mentioned earlier, you know, I'm not really an Instagram girly, but you can go to my website, which is mizecounsel.com. That's MIZECOUNSEL.com. I'm also on LinkedIn. My name, Jasmine Mize, JASMINMIZE. And those are places that I'm always communicating with folks. So please reach out. And I'm happy to work with folks on trademarking and patent questions. I think there's a lot folks can do on their own, but we always hit roadblocks where we need some professional advice. And I always tell folks, like, hey, just hit me up and we'll just work for an hour or two simple retainer, you know, like I just kind of give you the guidance and then you keep rolling with it. Like, you know, if this is not something that you think you can't do on your own but need a little boost. So just hit me up and we can work it out.
Total applause, man. Thank you so much for stopping by, Jasmine. It's been an amazing episode tonight, Cash Color Cannabis. And as a reminder, this episode is sponsored by TruLeaf. If you are a Georgia Medical Cannabis card holder searching for good quality products, please stop by TruLeaf. Flower, vapes, edibles, topicals, concentrates, tinctures, and more. Visit one of their 5 locations in Georgia and find out what fits you today. That's Cash Color Campus, a high level of conversation.